All right, our next case is case number 2023-0432, Mitchell versus Race.
Good morning, Your Honors. Just for the record, I'm going to be arguing 10 minutes, and I'm ceding 7 minutes of my time to the State of Florida Attorney Generals and reserving 3 minutes for rebuttal. So, good morning. My name is James Steen. I represent the petitioner in this case, William Mitchell. My client requests this court to reverse the decision of the 4th District Court of Appeal in Race versus Mitchell and hold that there is personal jurisdiction over the respondent, David Race, for 27 undeniable violations of the Florida Security of Communications.
Why doesn't your complaint allege the existence of jurisdiction under 481936, causing injury to persons or property within the state arising out of an act or omission by the defendant? You plead only that jurisdiction flows from 48193-2, committing a tortious act within the state. Can you help me understand why, I've looked at both the original and the operative complaint here, why you didn't just allege that the 27 phone calls caused injury in the state? Wouldn't that have settled everything?
That would have settled everything, and I guess if given the opportunity to amend, we can go ahead and do that. The primary reason at the time, though, Your Honor, was the existence of the France v. France case, which had already determined, I know we're now here reviewing to determine whether or not France was properly decided, but when we were pleading this, France was the most recent statement that had come out, and it said it's now 1A2, but it used to be 1B of the long-arm statute, said, that's it. The interceptions occurred here in Florida, and that's all you need. So that's really where we were going.
You would have said then that the tortious act was complete upon upon the speaking in Florida of the words that were intercepted. The tortious act was complete in the state under France v. France. That's basically your argument. Yes,
or that it occurred. I mean, the case law, particularly France, but I think more importantly, State versus Mozo, which we cited in our briefs, has determined that interceptions occur where the person's speaking. So my client, and by the way, it's undisputed that Mr. Mitchell was in Florida for all of the 27 phone calls.
Well, yes, but also the operative complaint doesn't allege that Mr. Race knew that.
The operative complaint doesn't allege that, but Mr. Race admitted in response to requests for admissions that he knew that my client was a Florida resident.
But he also specifically denied that he knew he was in Florida in the request for admissions, right?
He did, but it isn't necessarily, well, he hedged his bet a little bit. He denied that he knew that my client was in Florida when the calls occurred, but he did say that he knew my client was a Florida resident. It's no secret my client was a Florida resident. He's somewhat of a, dare I say the word, use the word celebrity in the video gaming industry, and so is Mr. Race, or at least he's trying to be.
Counsel, could you speak up a little bit? I'm having a little trouble hearing you.
Oh, sorry, Your Honor. I'm getting over a head cold, so I apologize for that. But basically, the gist of it is that State v. Mozo says that the interception occurred where my client was physically located at the time, which was in Florida. And there's really no reason to overturn that. That case is nearly 30 years old. It involves a statutory interpretation. It interpreted the language of the Florida Security of Communications Act, specifically the definition of oral communication. I would note that the State of Florida Attorney General's is supporting my client's position in this case.
Can I ask you about that, though? The Mozo thing, it cited a federal case that talked about the federal cases seem to arise in the connection where law enforcement is kind of a third party that's intercepting the call. And those cases are all premised on the idea that when law enforcement does it, that they're obtaining the call kind of where they're sort of redirecting. There's this kind of seminal case from the Second Circuit Court of Appeals up in Manhattan where it says, you're obtaining it / redirecting it from where the call is made. I don't know that analysis, which our court in Mozo didn't seem to really, it kind of miscited, to be honest with you, the 11th Circuit case. I don't know that when it's two people who are actually intended to be the parties to the call, that there, in that case, there's no redirection of the call by in this case, by the recorder, by the person who's out of state. So I'm not really sure that, Mozo might make sense in the law enforcement kind of third party context, but I don't know that that makes sense in this context. Can you address that?
Well, certainly, yeah. I mean, Mozo is interpreting Florida statutes, and I know this is an argument that Mr. Race made. There's really nothing, there's no reason that the language, or particularly the statutory definitions of, say, intercept or oral communication, wire communication, oral transfer, et cetera, should be determined differently in the context of an evidence suppression case, which was Mozo.
Well, but so the statute, the language itself doesn't tell you anything about how you're supposed to figure out this kind of question. And when Mozo, kind of without any kind of analysis or apparent thought about how this applied, doesn't purport to be doing any textual analysis, they just say, you know, see U.S. v. Nelson or whatever the case was. And U.S. v. Nelson is based on a specific set of facts about how the call was quote unquote intercepted. I don't know that we should just kind of mindlessly accept that.
Well, that's correct. I don't think this court should really mindlessly accept anything. But I would note, I guess as a 10,000 satellite foot view, nobody's asking this court to overrule Mozo. Even Mr. Race isn't taking that position either. We know Mozo, and my client knows Mozo because it's been around for a while, and we do think it decides the opinion or the outcome. But Mozo was, getting back to your issue about textualism, it interpreted the definition of oral communication, which is right there in the Florida statutes, and hasn't changed since 1997, really hasn't changed since 1974. And it kind of makes sense. I mean, it says oral communication means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation, and does not mean any public communication uttered at a public meeting or any electronic communication. I know that's somewhat long-winded, but the operative language is uttered by a person. How do you utter something in any place except where you actually are? In other words, how can my client, Mr. Mitchell, have uttered anything?
But 48 focuses on the actions of the defendant.
Correct.
So, I mean, I understand that there's a sense in which this is some murky thing about where is the conversation occurring and everything. But if the whole point of all this personal jurisdiction stuff is to focus on what the defendant is doing and the connection between what the defendant does and the form, I mean, everything the defendant did, the recording, the speaking, I mean, it was all in Ohio. In what state was he in?
Ohio. Yeah. That is correct. He was physically located in Ohio, according to his affidavit. If I can take 1 second, Justice, you raised a point about whether or not the defendant knew my client was in Florida. He did subsequently post on Facebook that he went to justia.com and copied Florida statutes for the Chapter 934 and copied it on there and said, you know, it is illegal in Florida to record a phone call unless all parties give consent. I'm paraphrasing.
I have questions about that as well, but I think if you could answer the Chief's question, then.
All right. The answer is yes. He was located in Ohio at the time, but for the purposes of committing a tort in Florida under the long-arm statute, if an intercept, and there's no reason to depart from Mozo in this particular instance, since intercept means that he intercepted the call. Let's write that. Since the law is such that where my client spoke means that the call was intercepted in Florida. In other words, under Mozo and under France and under the definitions of oral communication and other definitions in the statutes, basically Race intercepted the calls in Florida. It was enough to commit a tortious act in Florida. It is enough to state that the tort as alleged occurred in Florida, which is really all you need for 1B jurisdiction, or 1A2, excuse me. So,
on the due process issue,
sure.
How should we think about this case when I think it'd be fair to say there's at least a factual dispute over whether he knew, and if we're viewing the issue through the lens of the defendant's relationship, defendant reaching out to the forum state, there wasn't an evidentiary hearing below, as there typically is in personal jurisdiction cases. And so how do we address the due process issue when there's disputed issues of facts? From a legal standpoint, the analysis can turn on whether or not he knew that he was calling somebody who was located in Florida, and there was no resolution of the factual disputes in the trial court.
The short answer is remand. I mean, we can have a Venetian salami hearing. Basically, if I can, it's not really on the record, but I can give it back. I can give it background as to why there wasn't. We had this was initially assigned to one judge. That judge retired. We had a new judge. This was COVID. We had a case management conference. The trial judge said, we actually had a pending motion to compel jurisdictional discovery at the time. The trial judge says, no, we don't need that. Let's go forward. We're having a hearing in a week. I got everything briefed, and we did it. It was over Zoom. It was back in 2022. But if the court thinks that there are factual disputes, I mean, frankly, I could add more to the record anyway, more additional context, because I'm very certain that there are additional electronic contacts. So to answer your question, answer Your Honor's question, remand it back to the trial judge.
Do you think we can resolve it in favor of your client without remanding back?
Yes, you can. My client, the 1B issue, as I said, we believe is settled by Mozo and the statutes and the other case law. But there are sufficient context, either under the Calder test or specifically under minimum context. I mean, we have 27 undeniable phone calls. He's recorded calls with other Florida residents. There is a social media and internet and media campaign, all of which he's been directed at my client, which is frankly ongoing. I don't know if I'm allowed to say this, it's outside the record. I checked his prove all.
Don't you think we need something then indicating that the person who's recording the calls knows that the person is in Florida? I mean, I like the idea of us walking around the country with like this special bubble protection because we're Floridians, but I'm not sure that's how the law works.
And that's correct. I mean, but my client was in Florida, and he is entitled to the protection of Florida law while he's here. I mean, he never left Florida. We put the cell phone records into evidence, and if you look at the cell phone tower there, it's heavily redacted. It's the part of the record that's heavily redacted. The cell phone towers are all in Broward, and maybe one or two of them was in Miami-Dade. My client's a Broward resident. He's been living here for 40, 50 years.
You mentioned that perhaps that there was sufficient jurisdiction based on traditional minimum contacts.
Yes, sir.
Based on the fact that there were 27 phone calls. Okay, let me ask you this hypothetically. What if there was just one phone call?
What if there was just one phone call?
Yeah. Just one phone call that lasted 30 seconds.
Well, that's 30 seconds.
It was taped and then played someplace else.
There would still be minimum contact. I'm sorry for speaking over you, Your Honor. There would still be minimum contacts given the other additional electronic communications by Mr. Race. If your question is it one phone call of just one phone call only of Mr. Mitchell under the context of this case?
Let's say I got a call from Ohio and somehow it got through my office, and someone wants to know how come I ruled one way or the other. I guarantee you that call will take about 2 seconds. But nevertheless, it's taped, and all of a sudden I'm hearing myself all over the place saying I can't answer that question. Is that one call sufficient for me to bring this person into Florida?
If there are other minimum contacts, yes. If there aren't, then no. If this was in a vacuum and it was a one call of his 2 seconds and Mr. Race had no other contacts in Florida, then excuse me, then the minimum contacts or the due process test wouldn't be met, because that's which, by the way, is the instance in every case when we have a constitutional question. I mean, that's why the court said way back in Venetian Salami, you can't necessarily have a bright line rule for every case because it's fact specific and facts dependent. So in the situation that you just mentioned, Justice Labarga, if there was only one call but no other contacts beyond that, there could not be, it could be possible that there is not jurisdiction.
So actually, before you sit down, I want to make sure we're clear on that point. So you think that you could actually commit a tort in Florida under this hypothetical, i.e. by recording the 20-second phone call when you're not, you're in Ohio, and still, we would still have to do the due process inquiry? Because is there any case where a court has said that even if we stipulate that the tort occurred in the state, when I'm not saying that I agree with that, but let's just take that as a premise, that you still would have to go through this other, that isn't enough?
There's no case, at least that I've located, in which there is a stipulation that the long-arm statute was met and that the only issue was minimum contacts for the Florida Security of Communications Act. There aren't that many cases
But just in general, I mean, I'm kind of surprised to hear you saying that we could think that the tort occurred in Florida and that there still could be a question of whether due process was met.
Well,
I mean, I understand going through all that when the tort wasn't occurred in Florida and you're talking about effects and contacts and whatever, but.
Well, it's just because it's a hypothetical, Your Honor, and perhaps I didn't answer it the correct way. I mean, in a vacuum, you could, in theory, have a 1B or 1A2 violation and not minimum contacts. I mean, I don't know specific facts where that would occur, but that could, in theory, occur. And that's why the Venetian salami test is two-part.
Okay, we've taken you over your time.
Okay, thank you.
Thank you, Your Honors. Robert Shank for the Attorney General. As my friend aptly explained, this case is about the Florida court's power to vindicate an interest which this court said is one of the highest order in a free and civilized society. Justice Sasso, I want to briefly, before going to the statutory analysis, return to your question about the knowledge portion of this case. The fourth DCA, in its opinion, said that Race knew that Mitchell was in Florida at the time of the phone calls, and Mitchell has never disputed this on appeal. Now, I understand that there is a dispute in the RFAs below as it relates to one phone call, but my understanding is under Venetian salami and a quadro, the proper way when an individual believes there's a factual dispute about jurisdiction is they have to submit an affidavit specifically disputing the facts that they believe aren't present and don't establish jurisdiction. And if you look at Mitchell's or Race's affidavit below, he never challenged that he didn't know that Mitchell was present in Florida. So we proceeded, at least in our briefing, that Mitchell in fact, or Race in fact knew that Mitchell was present in Florida. Now I understand that there is some skepticism turning to the statutory question about the court's decision in Mozo, which largely relied on federal case law interpreting
Counsel,
identical.
before you kind of get to the details, I have a big picture question. Mm-hmm. Can you explain what the state's response would be to kind of what the limit is for the legislature to regulate sort of behavior actions of people out of state that affect Floridian citizens? I mean, is there a limit? Is there a point at which we would say, no, there's a jurisdictional issue? Kind of where does the state view the line there?
Right. So obviously, there needs to be a constitutional hook to prevent the legislature from passing such an act. I do think that we're going to locate that in due process in the traditional analysis, either a minimum contacts or the effects test. I don't think that there's much of a distinction here between those two tests because they shake out the same when an individual either commits a tort in a state. We think that is sufficient, or they commit an act that an intentional act that they know will cause a negative harm in that state. And I think that that's really the limit on the state's power. There does have to be some type of interstate activity. There does need to be, I think, a genuine bona fide harm in the state. And I think the legislature has identified that harm as a harm to the privacy interests of people residing in the state of Florida. And that can be seen from not the fact that the legislature has separated out separate torts, separate crimes for the intentional interception of a communication and then the intentional use or disclosure. So even if the person never learns about the act of interception, the legislature has still said that's a harm. That's something that harms a person the same way if a person trespassed across your property 2 weeks ago and you never learned about it until today. Your property interests are still harmed, even though maybe you won't sue about it because you don't know.
So the state's position would be, for example, that if I were on a business trip in Argentina and I received a phone call that that was recorded without my knowledge, I may not have a cause of action or maybe I do have a cause of action for the invasion of my privacy. I'm a Florida resident, but I'm not in Florida. But upon disclosure of it, perhaps I could say, look, I'm long-term a Florida resident. Just because the communication was intercepted when I was overseas, the disclosure of it I do find to be tortious, and I'm going to seek redress for upon my return to Miami or wherever I go.
Obviously, that's something that we haven't briefed here. I think it's a different case, but I don't think that would be sufficient. At the very least, I don't think it would state a cause of action because in order for a communication to be tortiously used or disclosed, I think would have to first be unlawfully intercepted under the statute. So you'd have to, I think that would only occur if there's some nexus to the state of Florida, which I don't believe would happen there merely because you happen to be a resident.
This goes to Justice Sasso's question about the protective bubble and whether the legislature has enacted this sort of, privacy sphere that follows a Floridian wherever he or she purports to go and what your remedies are. And what I guess I'm hearing the state say is we don't need to reach all of those questions. We, in this case, know enough to say that the protective bubble covers a Floridian sitting in Broward County, unless there's some affidavit from the other side saying, I didn't know he was in Broward County, I thought he was in Ohio or something like that.
Yes, our position is that under the facts of this case, it is sufficient. I think it's a different case and may involve a deeper analysis if there were different thresholds of knowledge. And so we just haven't briefed that case and we don't have a position on that. But again, we're not saying that there's this protective bubble that follows Floridian residents wherever they go in the country. We do think there has to be a nexus to the territory of Florida.
Can you tell me just, in terms of just the statute, whether you're talking about 48 or you're talking about the substantive non-recording statute, the knowledge of being in Florida isn't relevant. So walking through the due process analysis, which part of it is that relevant to?
I believe it's relevant to the minimum contacts inquiry. So there's three parts, right? Arising out of or related to minimum contacts, and then traditional notions of fair play and substantial justice. I think it fits most clearly in the minimum contacts analysis because, again, as the Supreme Court said through Justice Thomas and Walden, the connection has to be between the defendant and the forum. And I think that, at least in this case, we're saying knowing that you're acting or causing effects in a forum is a sufficient contact.
That seems like the contact is what it is. It seems like maybe I think the fourth in the decision below seemed to think that it was more a matter of kind of fairness, that you don't know where the person is when you call, you don't know what you're in a state where it's legal.
Well, I do think that, to the extent that the defendants have raised the Campbell line of cases, I think that's a different type of due process limit on a state's ability to regulate certain extraterritorial conduct. But I take your point that there may be some fairness concerns. I just have a hard time locating it in the multi-factor analysis that the federal courts have set out when it analyzes the traditional notions of fair play and substantial justice. I suppose it could fit within the forum's interest in adjudicating a dispute. But in any event, wherever it's located, we do think that the fact that he knew he was acting in Florida is sufficient for these purposes.
And do you agree that it's not enough to show that there was a tort committed, quote unquote, in Florida? That we still have to do the separate, because it just seems to me that if you commit a tort in Florida, if we accept that premise, which I don't, but if I did, then I would just think that the due process part would be a slam dunk. I mean, what would be left to do?
I certainly agree with that notion. I guess we haven't teased out the limits of that theory. Certainly if a person tried to mail a bomb into a state and said, well, I didn't know where this zip code was located, I didn't know that the plaintiff was in Florida, we don't think that they would be able to get around personal jurisdiction simply by saying, I didn't know. But at least for purposes of this case, we've only briefed the issue assuming that a person calling into the state of Florida knew that he was doing so. If there are no further questions, I will leave the rest of my time to my friend. Thank you.
Good morning, Justices. May it please the Court. James Toscano with the Lowndes Law Firm. This is my law partner, Rebecca Roden, representing the respondent, David Race. If the panel doesn't have any questions right off the bat, I'd like to...
Can I ask you a process question?
Yes, sir.
And I don't mean to be a fly in the ointment on this, but it seems like this was litigated in front of the trial judge on the premise that this whole thing was about the statute. And then the fourth kind of on its own did this due process thing, and then they certified a conflict in a situation where, I mean, you really have to strain to find a conflict, certainly in the sense of anybody doing any actual thinking about this. So what are we, I mean, we've had recent cases where when the DCA kind of went off on its own and decided something that wasn't presented properly to the trial court, we kind of said we're not going to sort of just take that and sort of build on that and rule on the issue. So why, to the extent that this case here, I guess in theory, is at least partly about the due process issue, why is that properly before us?
You're absolutely correct, Chief Justice Munoz. What happened is at the trial level, we were focused, because of a lot of the reasons that Mr. Steppen raised, we were focused on the long-arm statute prong of the analysis and whether a tort was committed in Florida. And then what the Fourth DCA did was it basically put that issue to the side, decided the issue on minimum contacts, but then yet certified the question with respect to the long-arm statute, and then, you know, this esteemed court accepted jurisdiction. So I agree with you in that regard from a procedural perspective.
So what do we do then? Because you lost in the, you know, so do we just limit ourselves to the statute? I mean, what's the right thing for us to do at this point?
I'm not sure we should be here, because the Fourth DCA decided on minimum contacts, and that was not the basis for the conflict. The conflict was with respect to the first prong of the long-arm statute. But here we are.
And our esteemed court's inscrutable footnote from that.
Yes,
a quadro or whatever.
And I think
not one of our finest moments.
Well, I'm not sure I agree with that, Chief Justice. I mean, the footnote is accurate. It says that a phone call.
It's kind of a non sequitur, but
right. It says the phone call into Florida may constitute a tort, and that's a factually true statement. I think this interception kind of took on a life of its own, and I think that the Coons Court addressed it probably better than anyone else. It said the cases we relied upon in Cook, and I understand that KOCH is pronounced Cook, did not address a jurisdictional issue, but rather involved statutory interpretation of the term interception, and that it cites to State v. Mozo and U.S. v. Nelson, which I can get into and distinguish. And it goes on to say that the theory that a recording in a distant location is an interception inside Florida may be appropriate for some legal purposes, but we conclude it is insufficient standing alone to support a claim that a person in a distant state or country committed a tortious act within Florida.
Yeah, but what support do you have, state or federal, for the proposition that the tort occurs at the locus of the recording? It seems to me like there's precedent, state and federal, for two propositions. One, that it occurs at the place of oral initiation, A-U-R-A-L, oral initiation, first place it is heard. And then there's the federal precedent, the listening post stuff, about how it occurs simultaneously from a metaphysical perspective in both places. There doesn't seem to be any case law supporting the proposition you seem to be arguing for, which is that the relevant act occurs where someone pushes the record button, and it seems to me like that stands for good reason. That stands to reason because there's so many, you know, imponderables that then flow from that. Is it from the cell phone tower? Is it from the satellite to which the cell phone tower beams the communication? So what I guess my question is, what's your best case for the proposition that the interception occurred in Ohio?
I don't think there is one, Your Honor. I don't. I think the case law does say that the interception, as far as the statutory interpretation, which is what the Coons Court was dealing with, is in Florida, where the communication was first uttered. But I think the distinction is it's from the privacy perspective. If you look at, in the Nelson case, the dispute was whether the wiretap order, which was issued in one district, applied because the state agents who were, the federal agents who were listening in were in a county outside of the district. And so that's how that was the genesis of how interception was originally defined under Nelson. And Mozo dealt with a cordless phone. But as Chief Justice Munoz pointed out earlier, the distinction is, in those cases, the interceptor is a third party. So there's a right of privacy, there's a communication between a Florida, and both of those cases, they're both criminal cases, they only deal with Florida residents, they both involve the statutory interpretation of interception, and neither one of them deals with jurisdiction. But from a privacy perspective, if you've got two parties having a private conversation, one of them's a Florida resident in his or her home, there is a reasonable expectation that there's not going to be some third party there's not, the state, Big Brother is not going to be listening in on that conversation. But if there's a two-party conversation and one of the participants is the interceptor, then I don't think that there's a reasonable expectation that the person who is hearing the communications won't then relay that to some other third person.
Well, but there is, if you're in Florida, when you're speaking on the telephone to someone wherever, there is a reasonable expectation that you're not going to be recorded unless you've given permission. Right? I mean, that's what the law is about. I mean,
well, I guess if there's a reasonable expectation that's the law.
Reasonable expectation that, you know, we assume that the people know what their rights are under the law. I mean, that's part of what we would assume. And that's, it just seems that there is that expectation that, you know, when I get on the phone and I'm talking to somebody, I assume, unless they've told me, they're not recording me. Now, not that I would care.
Well, and that's a good point.
But some people might care. And you've got a right to care because you've got a right under Florida law not to be recorded surreptitiously.
And I absolutely agree if that's two Florida residents having the conversation. But Florida is one of only 11 states that has all-party consent. I mean, I don't think it's reasonable to assume that...
Well, but that doesn't make us chopped liver. I mean...
No, I think obviously there is a right to ensure the privacy protection of Florida residents. And Your Honor just said it. You wouldn't care. It's an accurate transcription of what you said.
Well, I said I might not care.
You might not care.
Some people might.
But the statute...
I mean, I can understand that it's not unreasonable to think that there's some sort of violation of recording a private conversation. That you, when there's a right to not have it recorded without being told that it's being recorded.
Well, the right is a statutory right, and the statute doesn't require any showing of damage. And so if you're going to impose this statutory requirement...
Damage to your dignity.
In some instances, I would rather have an accurate recording of what I said rather than have the recipient you know, not accurately relay it to a third party.
Can I ask, so if we're trying to sort of do this from a kind of textual perspective, and if you read the text of 48 whatever, and you think that there isn't really a sort of clear reading from a textual perspective that would tell you where, you know, where the tortious act is occurring, or at least where the defendant's part of the tortious act is occurring, where do we go to find sort of the kind of external, whether it's canons or principles or whatever, to kind of inform how we should use our judgment to figure out that tie? Because it seems like in Altenburn talks about strict construction, and it seems like he's kind of trying to smuggle in some of the due process stuff into the statutory analysis. So, like, what would you, if we don't think that it's just a matter of whipping out the dictionary,
right,
then how do we resolve that?
I think, and there's lots of overlap, right? I think there's overlap both between the two prongs, and then in the second prong there's overlaps between the effects test, minimum context, and notions of fair play and substantial justice. But I think the way to look at it is Mr. Race reaching into Florida to commit a tort? Or is he in Ohio with the app on his phone doing the recording? And I think in this case, from a constitutional due process perspective, Mr. Race isn't reaching into Florida, but Florida is reaching out into Ohio and administering a statute that is effectively punitive.
I'm not so sure about the reaching in, reaching out. Let me ask you the same question that I asked your friend at the outset about 481936. Do you concede that the operative complaint alleges the causation of an injury to person or property within this state? Because it seems to me like if you do, game, set, match. I mean, like, we're arguing about whether or not a tortious act was committed in the state. And let's just put that aside for a minute. If the complaint alleges that injury was caused to a person within this state by an act or omission by the defendant outside the state, then all of these metaphysics go away.
To some extent, I would agree with that. I think In A, it doesn't allege that, but if it did, and taking that as true, that would be a tort committed in the state, correct? And I think to
Well,
Chief
no,
Justice,
but you see, there's a reason the statute splits the two.
right?
The statute says a tort will get you there.
Yep.
And then the statute says something else that must be different than a tort, or else it would be surplusage. And what it says is causing injury. Like, you know, I'm standing on the Georgia side of the Florida-Georgia line, and I throw a rock across the line. I may or may not, like, have caused a tort. Maybe I was throwing the rock to my friend and I missed and I hit somebody instead. But I committed an act that caused injury in the state of Florida.
There you go, right there. There is no injury in the state of Florida.
Well, no, but here the complaint alleges an injury in the state of Florida.
Understood.
So it makes it a statutory no-brainer, but you're still
Understood.
left with the due process
Understood.
stuff.
Right.
Understood.
So is that? But I guess, is the chief right? Is your refuge due process, because basically the statute? Yes, this could have been the operative complaint could have been amended to state 6 instead of 2. But
Under that circumstance, I would agree with you
You
that
take
my
refuge in
refuge
due
is the
process.
second prong of the analysis. Yes, because we're taking the allegation as true, obviously, at the motion to dismiss stage. I would have to concede that, Justice Curiae.
okay.
So are you aware of any due process case where it was accepted that the tort occurred in the state, and then when you get to the sort of minimum contacts and whatever, all that you would still say that it violates due process for that to be litigated in the state where the tort occurred?
I mean, the case law is clear about the two prongs, right? But I think that's kind of
It
what
seems like
the
it
France court
swallows it up.
did.
I mean,
I think that's kind of what the court in France v. France did. They found that the tort was committed in the state, and then they just...
because I just keep coming back to the sense that you either win on your statutory thing and then the due process goes away, or if you lose on the statute, I don't see how you could lose on the statute but then say, oh, even though the tort was committed in Florida, we can't litigate the case here. That doesn't seem right.
And, Judge, you took the words out of my mouth. That's what I said at the hearing in front of the trial court, and that's why it was a rifle shot argument with respect to whether the tort was committed in Florida, given the allegations of the complaint. We did not focus at the hearing at the trial court on minimum contacts. To Justice Sasso's point, we didn't have an evidentiary hearing. We were really just focused.
So when we're dealing with this, we really are limited to the statutory issue. I mean, to go off into the due process,
I agree.
We're talking about things that really the parties here did not litigate.
I agree, and to Chief Justice Muniz's point, the decision of the fourth DCA was based on the second prong, minimum contacts. And so it certified the question with respect to the first prong. But that wasn't the basis for the decision.
So you say discharge jurisdiction. That's really what you want us to do.
We're here, and we briefed jurisdiction.
Respondents always say that.
We briefed jurisdiction. I'm happy to be here. I wanted to be here, so I wanted the court to accept jurisdiction. But I struggled with the issue that Chief Justice Muniz raised with respect to what is the conflict in terms of how the case was decided by the fourth.
Well, the reality is there doesn't actually have to be a conflict if they certified a conflict. We have jurisdiction.
Well,
And the question
I'm not
is,
arguing
there might be
jurisdiction.
a prudential judgment about whether we would exercise it or not, but no one questions that we have jurisdiction of this case.
I'm not arguing there's no jurisdiction. I was responding to questions. At no point did I ever take the position that this court does not have jurisdiction. That's not my intent.
What you would take the discharge.
Are you offering? Happily.
To the extent there's a duty owed not to record calls, do you think that in terms of evaluating whether a tort occurred in Florida, we should focus on whether there was a duty owed in Florida? Or is it the obligation not to record and we focus on Ohio? Or do we focus on duty is owed not to record Floridians' phone calls in Florida and we focus on that for the purposes of determining where a tort occurred?
Well, you know, I can't argue with how interpretation has been defined in the case law. And interception has been defined. And an interception is a violation of the statute. And so that's why I quoted the Kuntz court in distinguishing the statutory interpretation of interception versus the jurisdictional analysis, which I think is more appropriate. And that obviously dovetails into the privacy concerns. But to answer the question, I think it should be limited to a Florida resident speaking with a Florida resident, and under the circumstance of the interceptor being a third party. I'm not sure how it translates into a two-party conversation when the recipient of the communication, could take extensive notes, could take accurate notes, could, to the extent that the recipient knew shorthand and was able to transcribe accurately the conversation. If the recipient then relayed that, there would be no violation of the statute, and there would be no harm.
So this is a criminal statute, and we have a section 910.005 that talks about state criminal jurisdiction in general, and it says, a person is subject to prosecution in this state for an offense that he or she commits while either within or outside the state, if the offense is committed wholly or partly within the state. And then it says an offense is committed partly within the state if either the conduct that is an element of the offense or the result that is an element occurs within the state. So I'm wondering, should that inform our analysis at all?
I think that would run afoul of fair play and substantial justice. If you've got someone sitting in
just on the statutory part.
On the statutory part.
As far as whether because I think, it seems to me the whole case hinges on whether we really think the tort occurred in Florida or not in Florida.
Well, under that reading and under the case law, I think the conclusion is the interception, which, the problem is it's not really a tort. It's a statutory violation.
Violation. But tortious, we're assuming.
A tort is a civil harm.
That's where you and I differ. There's no harm.
It's a violation of a legally protected interest.
Absolutely.
That's a tort.
And you accept that it's tortious, that a violation of this statute, if there was no dispute that it was violated, you would consider that tortious activity or conduct or whatever the jurisdictional.
Understood.
Okay.
Yes. If there are no further questions, I'll yield the rest of my time.
Thank you.
Thank you.
Thank you, Your Honors. I will try to make this very short. I do agree with, I guess, what appears to be a consensus that this case can be decided on whether or not a tortious act was committed in Florida under the long-arm statute. And at the end of the day, it was. Intercept has been determined by the case law, particularly Mozo, but also the other DCAs, as occurring where my client spoke, which was undisputably in Florida.
And tell me why textually, put the case law aside, and I'm not saying that we should or would do that, but tell me why textually, how am I supposed to know that that's where the interception occurs in the context of the two people who are the intended participants in the call?
Because you can't have an oral communication as defined by the statute unless it's uttered by a person. And obviously a phone call is an oral communication, as Koch v. Kimball recognized.
But is an interception the key word?
Yes, it is. And interception, I will agree that interception doesn't state in the statute where interception occurs, whether it.
Okay, so that was my question. So what if I'm going to find the answer in the statute rather than in the case law? How am I supposed to know where the interception occurs?
Well, then you look to the other definitions, particularly oral communication, uttered by a person. How do you utter something where you're not present?
Yeah, but that doesn't tell me where it's intercepted.
It does in this sense because,
First of all, it's not a natural use of language to refer to recording a call that I'm on and that I'm intended to be on as an interception.
That's correct.
Right? So this is all kind of a construct. So textually, is there anything that tells me where the interception occurs?
Oral communication, also the definition of oral transfer, that's A-U-R-A-L. That's in there.
That's hearing.
That's hearing, yes, but it means a transfer containing the human voice at any point between and including the point of origin and the point of reception.
Let me take a shot at this. I think we've been very fixated on the interception or the recording as if it happened in Ohio. But the truth of the matter is that what is recorded, this voice communication between these two phones, is just as recorded in Florida as it is in Ohio, right? Like, the technology is recording that oral thing that is being uttered in Florida. And to me, there is no other point at which it makes sense to draw the line other than the first place where it is heard. There's no logically satisfactory alternative to where something is first heard, because what is recorded is in fact that line of communication. It's not like it's being recorded by a tape machine in Ohio. It's that whole communication that's being recorded. This is me talking. This isn't necessarily you. But is that what you're arguing, that essentially the recording happened in Florida because that's where the communication was complete? Like without Florida, there is no recording.
Yes, I think that sums it up.
But why isn't the right question what the defendant is doing? I mean, it seems like there's this sort of like, how do we sort of metaphysically view the conversation and where it's happening and whatever. But it seems like the whole point of this area of the law is to focus on what the defendant is doing. And the defendant is making the decision to record, he's hitting the button. None of us know like where things are bouncing off towers and whatever, but in terms of everything that the defendant is aware of, it's all happening in Ohio. In terms of the recording part of it, not the conversation part.
Well, you mean the physical act of the cell phone app that he had on his phone that recorded every phone call? Yes, that was in Ohio according to what he said. So his phone was in Ohio. But the defendant, at least in this case, he knew my client was a Florida resident, and I mean, he's recording calls of them. He recorded calls with other Florida residents. So if you want to focus on what the defendant knew and did, I mean, he had a pretty good idea. If he didn't know outright, he had a pretty darn good idea. He was talking to a Florida resident. It's a 954 area code. My client was fairly well known to be a Florida resident in the context of the gaming community. So for him to say that he didn't have any idea that Mr. Mitchell was a Florida resident is just wrong, and frankly, he's not even taking that position.
Okay, thank you. You can have 30 seconds to finish up.
Just for all the foregoing reasons, Your Honor, we ask that you quash the decision of the 4th District and remain back to the trial court for further proceedings. And also, I know this didn't really come up in oral argument, but there was a secondary issue, which was appellate attorney's fees. The statute 934.10 has a one-way street for a prevailing plaintiff. We move for attorney's fees.
So this is rebuttal.
Oh yeah, okay. So that's the gist of it. With that, I'll sit down.
Okay, thank you. We'll be in recess for 10 minutes.
All rise.